Do you want your children to go through months or even years of frustrating and challenging court proceedings? Would you want to unleash the anxiety of not knowing what's going to happen to mom and dad's money or estate, possibly suffer financial hardship themselves, and take time away from their own family? And knowing that all of this information or proceedings are on public display. What if you could easily help your children to avoid this? Welcome, everybody. I'm Patrick Seaman, and today we're going to be discussing the exciting challenges of estate planning, kind of a process of arranging how your assets, your estate will be managed after your death or while you become incapacitated. We will talk about wills, trusts, POAs, fun stuff. You don't want to miss this, as I always say, because planning for retirement shouldn't be a mystery, but rather simple and straightforward, and that's what we're here for. I'm here today with my guest, Rick Arnold. He's an attorney from Arnold Gruber in Canton, Ohio. Rick is the managing member of Arnold Gruber and has about 30 years of experience advising individuals and businesses in Northeast Ohio, not only in estate planning, but other areas like business law and taxation. By the way, he's also a CPA, and prior to his legal career, he served as an Army officer. So with that, Rick, I'd like to thank you for joining me.
Yeah, thanks for having me, Patrick. Looking forward to it.
All right. Well, I'd like to kind of start with something. I think before someone begins to work on an estate plan, they would have to know what they want to happen, with their estate or their assets, kind of the who and the what. So along those lines, can you give us some ideas or suggestions on what people should think about first, maybe even before they come to meet with an attorney or someone like you?
Mm-hmm. Well, I think in your introduction, you kind of hit the nail on the head with respect to making it a smooth process for the beneficiaries as well. When you were talking about time-consuming court costs, public information, that's all part of the probate process. Probate being an old Latin word that means prove who owns those assets, and it requires that process of going through the courts to determine who the rightful heirs are. Because of the cost, because of the time, because of the administrative headaches to beneficiaries, probate has kind of become a little bit of a dirty word. So we try to avoid probate. And there's many ways to avoid probate. The best way to avoid probate is probably having some type of trust arrangement where those assets pass automatically as a result of passing through the trust. There's other ways to avoid the probate: joint survivorship, payable in death, beneficiary designation. But the trust seems to be the best method. So that's probably the first thing when people want to talk about doing their estate plan is, how do I make it smooth for my beneficiaries? How do I avoid that probate process? Like you also said, the next step is to determine who do you want to inherit those assets and how do you want them to inherit the assets. Again, if you've got beneficiaries who are underage, beneficiaries that have a disability or otherwise can't manage their funds, leaving that to them outright may not be the best approach. It may be a better approach to keep it in a trust arrangement and make sure that money's available for them, maybe doled out as time goes on. But not just given to them in a lump sum. So those are two of the things that I think we think about when we primarily when we're talking about first establishing your estate planning.
All right. Hey, just to back up a little bit, I kind of want to get a little bit, maybe ask some more simpler questions, but I think I want to touch on a lot of the things that you just discussed. First of all, think about who should inherit their assets and what assets should they inherit. Particularly if they're married, they have children. I have clients that do not have children. I have clients that are not married and do not have children. So I think that's certainly one question. But if they do have children, who inherits what? What if they have a business? What if they have rental properties? Kind of what's your experience with that?
Yeah, I think it's a very good question. Let's take the example of a business. You may have a business, you may have several children, but maybe only one child or two children are involved in that business. The other ones aren't. So how do you treat your children fairly, but at the same time make sure that the child or children who are actively involved in that business are inheriting that business? On another standpoint, something that I see very commonly anymore, Patrick, is blended families. Second marriages, children from the first marriage. So you've got children, stepchildren, so forth. And, in almost all cases, I think, my clients certainly want to take care of their spouses, but, they don't necessarily want to leave those assets to anybody other than their children after the spouse is gone. So a lot of times it requires some type of arrangement where that spouse has access, maybe a life estate in the assets, but when that surviving spouse passes, they want it to go to their children, which is natural as well. So again, thinking of the question of who do you want it to go to isn't always the easiest question. And, sometimes it becomes very complex because, like you said, there's particular assets that are better suited for particular children, particular beneficiaries. And sometimes you don't want to necessarily leave all of your assets outright. You may want to have a life estate to a surviving spouse or somebody else, but you want that remainder interest to go to somebody other than that surviving spouse.
The other thing is rental properties or maybe like a vacation property or a cottage. And you think about how do you pass that on to your children? Maybe you could talk about that, but also kind of the tax implications of that.
Mm-hmm. Yeah, absolutely. Yeah, vacation home is a good example of that. For a long time, I was giving seminars at vacation locations, up on the lakes and Chautauqua and different places, because people would have a vacation cottage that was in the family. And the idea with the parents was, we don't want to sell this asset. This is an asset that's kind of a family heirloom. We want to pass it down. We want all the children to be able to come together and enjoy the property. We want the older generation's picture above the fireplace, and this is going to be kind of our legacy to the parents.
Yeah, I could see that.
In reality, it becomes a lot more difficult than that because, again, you may have several children, and maybe one or two of the children, use the property on a regular basis. Another one maybe have moved out of state in California. They never have the opportunity to enjoy the property. Maybe a couple of them can afford to continue to keep up the property, but be able to keep up the property. But at the same token, the other children can't necessarily keep it up. So it becomes very complex. A lot of times we call.
Even how to afford to take care of it if there's a new roof or different things need to be done to the property.
Yeah, absolutely. No, again, if you can endow the property, you can say, okay, in addition to leaving the property to my children, I'm going to leave, $500,000 as an endowment to be able to keep up the maintenance and upkeep of that property. That kind of solves the issue of the finances because then the children aren't going to be responsible for it. But unfortunately, a lot of clients can't. They've got the property, but they can't leave enough money to permanently endow the property and the maintenance of that property. So a lot of times, you have to come up with kind of a special, a trust arrangement. We call it cottage law arrangement for that property, where you determine who can use the property. If they don't pay their share, what happens? If somebody wants out of that property, how do they get out? A lot of times, if a child says, well, I have no interest in that property, my siblings may go there, but I live in California now, I have no interest in going to that. So I think you want a fair arrangement of how that child is able to get out. And then we also have the issue that I call the rabbit effect. You may have 3 or 4 children, okay, but then the 3 or 4 children may turn into 20 grandchildren, which may turn into 60 great-grandchildren as well. So under that rabbit effect, I think you have to have an arrangement that once you start to get too many owners of that property, how's that property going to be managed? A lot of the issues are, with the property, if you've got 3 or 4 children, are they allowed to invite the neighbors? Are they allowed to invite their friends, or is it just for family?
Right.
Who's going to take care of that property? Are you allowed to bring the pets? Yep. All of those things that you don't think about. And the problem with it becomes, the thing that was supposed to bring the family together, which is a family cottage that everybody can get together after mom and dad are gone, sometimes is the very thing that tears the family apart.
Yeah. So the legacy they're trying to leave. The intention is something very good, but ultimately it hurts the family. So, hey, moving on very quickly with respect to rental properties, maybe you could talk about some of the advantages of leaving rental properties to your children versus, and this is a big challenge for my clients in that we see, they have rental properties. As they get older, they no longer want to manage them, or they're not capable of managing them. But the tax advantages of leaving them are enough that they would want to consider keeping them and leaving to the children. Maybe you could discuss that a little bit, particularly with your CPA background.
Yeah. There's actually a great way to create wealth. Intergenerational wealth is through real estate and through properties. So let's take the rental property. Maybe residential, commercial rental properties as well. You could buy those properties. Obviously, they appreciate over time. But there is a code section. If you ever want to cash out on those properties, there is a code section. It's code section 1031 called like-kind exchanges. And what that means is essentially, if you have a property, you decide you want to sell that property, but instead of paying the capital gains upon that sale, what you do is you reinvest all those gains over into another property. You can continue to defer that property throughout your lifetime. So again, as an example of that, you can buy a property for maybe $100,000. So, hold on to it. It appreciates. You sell it for $300,000. You roll it into another property. That property, appreciates. So you're building up that capital gain as time goes on. Now, again, it's just deferred. It doesn't mean you're not going to pay the tax on it, but there is a way to not pay the tax. Under the Internal Revenue Code, there's also a provision that essentially says if you leave property to a beneficiary through your estate, they get a step up in basis to fair market value. So an example of that, let's say you bought a rental property for $100,000, it appreciates to $300,000. You then roll it over into another property. That property appreciates to $1 million from that $100,000. And then instead of selling that property, eventually what you do is you pass it to your estate. Your children will inherit that property, never having to recognize any kind of capital gain or loss. So their tax basis becomes whatever your tax basis on it was as well. And it's a great way to create wealth, to create an intergenerational wealth, because again, you're never recognizing any tax on the appreciation of that property as time goes on.
Now, what if it's their home? Is that the same thing apply, or if they inherit, if they sell their home, would they pay the tax?
The same principle applies. The difference with a primary residence is with that primary residence, if you sell it, then you can defer a certain amount of gain on that sale as well. But same thing with that home. If you were to pass your home to your children, they receive a step up in basis to whatever fair market value is on the date of your death. So again, I've got clients who might have bought their home in their 60s, and that home they may have paid a few $100,000 for, and maybe now it's worth $1 million. If they pass that on to their children, their children's tax basis now becomes whatever fair market value is at the date of their death. Right. If the children turn around and immediately sell it, they have no capital gain or loss on that as well.
So kind of moving on, another question, it's just my clients, people have assets, properties, businesses, so forth. Or what choices do they really have for transferring those assets at death?
Yeah,
I think we're talking about wills, trusts, beneficiaries. I just answered that question, but go ahead. I'll let you maybe expound upon that.
Good answer. Yeah, and again, there's several ways to pass assets. Again, you could pass them through your estate. You could pass them by virtue of beneficiary designation, transfer on death, a gift during your lifetime, as opposed to passing it through your estate. But again, typically the best way is to try to avoid probate with those transfers. So what you want to do is you want to put those assets into your trust, and then when you pass, those assets could pass by virtue of whatever arrangements you've already established within your trust to pass those assets. You bring up a good point too. We were talking about if you pass assets through your estate, you get a step up in basis to fair market value. The same is not true with a gift. So again, for example, if you have a property and it's highly appreciated, and you gift that property to your children, they're going to have whatever your tax basis was on there because you gifted it to them, right, as going to your estate. So a lot of what our estate planning is again, it's a little bit of an art and a science when in determining what's going to be a lifetime gift as opposed to passes through your estate. You really want to look at those assets and say, maybe that's not the best asset to gift. Maybe this is a better asset to gift. And because that asset's highly appreciated, that's one you want to hang on to and then pass through your estate as well.
So when would you recommend using like a trust versus a will when we're talking about passing those assets on? And really, what's the best option?
Yeah, I would say for probably 80% plus of my clients, we have a trust. And we have a trust for a number of arrangements. On the far end, we may have somebody that's subject to federal estate tax. And as a result of that, we use that trust arrangement to try to minimize that federal estate tax. On the opposite end, maybe you've got a young married couple, and they don't have a lot in the way of assets, but they have some. And they may have small children. And again, they're using the trust arrangement not because they're trying to necessarily preserve wealth, but because they don't want their children to inherit at age 18. They want to make sure those children are protected. So really that trust arrangement, I think, in almost all cases can be beneficial for any size of estate and at any point during one's lifetime.
And I think it's interesting, right before we started this webinar, we were talking about a particular client of mine, and we were really talking about using both beneficiaries on their accounts as well as the trust kind of in conjunction with each other. It seems to me it works out very well, particularly with IRAs where you're passing on to a spouse or to your children. There's some benefits to just listing that spouse or the children as a beneficiary. Maybe you could explain what that is.
Yeah, absolutely right. People ask me, okay, once I created that trust, what should I put in that trust? And my answer is, well, you should put almost everything in that trust because, again, you want to try to avoid probate. You want the creditor protection provisions that are included in that trust. But there may be two, maybe possibly three assets that are an exception to putting in your trust. The one, like you mentioned, Patrick, is, if you've got any kind of qualified retirement account, 401k, IRA account, then typically with those accounts, I think you're better to have a beneficiary designation as opposed to the trust to avoid probate. And the reason for that, again, with each of those accounts that are qualified accounts, there's a deferral. There's deferral provisions as well. And you just seem to have a much better deferral if that asset isn't passing through the trust first, it's passing directly to that beneficiary. Now, I do have exceptions to that. I've got some clients who, have a large retirement accounts. They make the spouse the primary beneficiary, but their children are underage, and they don't necessarily want those children at age 18 to inherit that property, even though they may stretch it out. Because the children at age 18, they're not concerned about their retirement. They're going to live forever, and they're never going to retire. So, the preference for them is, rather than, use it for retirement, we're going to use it for the Porsche. So to protect it, in cases like that, I have some clients who say, I'm more concerned about the protection than I am the deferral provision. So they will make the trust the secondary beneficiary until the children are a certain age as well. So that's the first asset that I would keep out is a qualified retirement account. And then the second asset, vehicles are kind of a high risk asset. So you hate to put those in the trust and subject the trust to that liability. So again, with vehicles, I typically recommend that those vehicles have a what we call a TOD, or a transfer and death beneficiary designation, which you can get through the Bureau of Motor Vehicles. If you just take your title to the Bureau of Motor Vehicles, they can establish that for you. And that would cause that vehicle to automatically pass through whoever you designate.
Yeah.
As a third asset, then sometimes, the checking account that you use on a regular basis, you may not keep a lot of money in that account. Sometimes I say because it's a small account, not a lot of money you use on a regular basis. Sometimes that's easier just to have a joint survivorship account between spouses, or beneficiary designation as well.
Sure. Yeah, it's also important that your estate plan to address incapacity due to illness. Maybe you're cognitively impaired and injured, you're older, a lot of other circumstances. But can you talk about what estate planning options people have for making financial and healthcare decisions if they do become incapacitated?
Yeah, absolutely. And again, this is another place where the trust can come in handy. If you become incapacitated, but your assets are in the trust, sometimes it's not necessary to declare you incompetent to have a guardianship of your estate because your assets are already in the trust. Your successor trustee can step in and say, hey, the assets are already here. I know what I'm supposed to do. I'm supposed to take care of you with those assets as well.
And the trust defines that.
Right. Yeah, the trust defines, the trust contemplates your incapacity, your incompetency at some point in time, so that somebody would step in, your successor trustee, use the funds in the trust for your care and benefit as well. So that's another benefit of the trust. But then in addition to that, a lot of times what we want is a financial power of attorney. Healthcare powers of attorney are to be able to make healthcare decisions, but you typically want what's called a durable power of attorney for property, or a spring power of attorney for property, so that if you do ever lose capacity, or even if you don't lose capacity, but you just can't get to the bank, or you're laid up in the hospital, with that financial power of attorney, somebody can act on your behalf. Now, again, that financial power of attorney is a very powerful document. We attorneys kiddingly call it a license sometimes, because with that document, somebody can do whatever's on your behalf. But it is a very helpful document, particularly if you got.
Yeah, I think particularly between spouses, it's so important. I know I had one client that you'd worked with who did not have the power of attorney, and her husband became incapacitated, and she needed to get access to his IRA money. Well, that account was in his name. She would normally not have access unless she did have that durable power of attorney. And so that kind of put her in a quandary, and I think you were able to go out and get that power of attorney signed by him. And ultimately, she had access to that money, but it was a little touch and go because of what was going on with his health. So,
yeah, understood.
A little stressful. So, maybe you could talk a little bit more about like living will, why it's other types of legal documents that people would need.
Yeah, a complete estate plan usually consists of several documents. The simpler documents are the healthcare powers of attorney. A healthcare power of attorney, you're unable to make your own healthcare decision because you may be unconscious, may be under anesthesia. And with the healthcare power of attorney, you're appointing somebody while you're in that condition to be able to step in and make healthcare decisions on your behalf. Kind of hand in hand with that is a document called a living will, which is neither a will nor a living trust, but it's a living will. And that's a document that essentially says if you're in a permanent comatose state, no quality of life, no continued consciousness, would you want to be maintaining that condition or not? Because again, a physician's duty is to maintain you regardless of quality of life. And most people say, listen, if I'm in that condition where there's no quality of life, I don't want to incur that expense for my family. It's no benefit to me. There's no consciousness. So I don't want to be maintained. So that's what the living will document will do. Again, we talked briefly about a financial power of attorney as well, which is a good document. We talked about the trust. If you have a trust, you still typically have a simple will, because again, no matter how hard you try to get all those assets in there, there's also a possibility that something may slip through the cracks, unclaimed funds that you weren't aware of, or a bank account that you weren't aware of. And what the will do is it's a simple pour-over will that says, hey, if it's not already in the trust, give it to the trust, give it to the trustee. The trustee knows what to do with it. Well,
By the way, just to clarify, you said that really fast. You called that a pour-over will, correct?
yeah, I'm sorry, it's a pour-over will. And the idea with that is it just simply pours it over into the trust document.
Right. Okay.
And then finally, again, I've seen beautifully laid out estate plans where you have the wills and the trust and the other documents, but people don't take that last step, which is to fund the trust. And by funding the trust, that means you've got to put the assets into the trust during your lifetime. Otherwise, you're not getting the benefit. You would still have to go through the probate process to get them there as well. So typically with our estate plan, we have, a series of documents. We assign your personal property to your trust. We'll do a simple deed that deeds your residence or your other property into your trust. If you have a business and we want to make sure that the ownership of that business, the stock or the membership units are owned by the trust as well. So it's, again, you can have a beautifully laid out estate plan, but if you don't take that final step, you're not getting the full benefit of it.
One other thing I want to touch on before we leave, and this is almost worth just a separate webinar altogether, would be Medicaid, and then a lot of the documents and things that you're talking about. Do they have anything to do with Medicaid? And that is in protecting yourself from Medicaid spend down. So, as our clients get older, they're starting to think, hey, am I end up in a nursing home or need some type of assistance at home or an assisted living facility? Are any of the documents is that going to help protect them from Medicaid spend down? That is, they have to spend their assets down before Medicaid would pay. And if not, is there something that they can do or that you recommend?
Yeah, good question. And like you mentioned, we could probably spend 3 days on the Medicaid
Absolutely.
and barely touch the surface of it. But again, if you need long-term care, then there's really only 2 ways to pay for that long-term care. Either you private pay, and then once your money's gone, then Medicaid will come in. Medicaid being different from Medicare. Medicare, you turn 65, it's health insurance. Medicaid, on the other hand, isn't based on age, it's based on financial need. But again, there's a lot of tools with Medicaid planning. It becomes very complex. If you're a single individual, you don't have a spouse, it is much less complex. You're only allowed approximately $2,000 worth of assets. You have to spend everything else down before you qualify. When you're a married couple, it becomes very complex because you have the spouse who needs the long-term care, who they call the institutionalized spouse, but you also have a spouse that may be living in the community called the community spouse, and they don't want to completely impoverish that community spouse. So there's certain assets, certain amounts of assets that community spouse is entitled to as well. Everybody's familiar with that 5-year look back, where they look back 5 years and determine what your assets are, what transfers you've made, and if any of those transfers are deemed to be improper, they bring those back in your estate. But again, I guess from a 30,000-foot view, Patrick, the idea is there's a lot of tools that we have for Medicaid planning. Yeah, absolutely. So if you've got a situation, whether you're a single individual or whether you're a married couple, there's planning that we can do to try to preserve those assets. As long as we do it legally and follow the rules. There's nothing that prevents us from trying to preserve as much as we can for the spouse that's still in the community or the children eventually.
Is that type of planning something they do when they're 65, or do you typically wait until they're like it's impending? They need that Medicaid, they need that nursing home.
Yeah, you hate to impoverish yourself when you're too young because you may at some point in the future need that long-term care. So typically what I say is it's based on your condition, your health condition. I mean, you may have somebody who's in their 60s. Unfortunately, may be looking at some type of long-term care in the future. Other times you may have people in their 80s and they're perfectly healthy as well. So I think it's really, when you're looking at your health and saying, hey, at some point in time, long-term care may be needed. Going back to your original point too, you asked about those documents, and if you have a typical revocable trust as part of that estate planning, that's not going to help you from a Medicaid standpoint, because again, the reason behind that is you still have access to all those assets. They're still for your benefit. You still have strings of incidents of ownership and control over those assets. So those typically won't work. For Medicaid planning, we typically use different types of trusts. As opposed to a revocable trust, we would use an irrevocable trust or some other type of planning technique. So your typical estate plan, just because you have a trust, is not going to help you with Medicaid. You have to have a special Medicaid irrevocable trust in order to benefit from that.
So I need to wrap this up, but one last question I wanted to ask you is what is a really good time in someone's life to be doing this type of planning? Not Medicaid planning, but estate planning. And also, if they already have done this, created an estate plan, maybe a trust or a will, power of attorney, maybe it was 5, 10, 15 years ago, should they have it reviewed, or how often should they have it reviewed?
Yeah, 2 good questions. Again, the first question, when should you look at this? I think from a very early age. I mean, even if you're young, but you're contemplating marriage, and certainly if you have children, you want to make sure those children are protected. That's when you should start doing your estate planning to make sure that it meets with your wishes as well. So I would say as soon as you turn 18, you better have at least a simple law in place, and then something you can always change as time goes on. As far as changing your documents, again, I always encourage my clients about once a year, take out your estate plan, dust it off, because a lot of times you think you know what's in that estate plan, but then when you look at it, say, well, gosh, I didn't realize I had that person. I haven't talked to them in 5 years, or I no longer want them as a beneficiary. So at least once a year, I would say, take out your documents, dust them off, and then maybe every 5 or 6 years, it rises to the level where something's changed in your life, where it's time to update those documents. Once you've got a good estate plan, just tinkering with them or updating those documents is much easier than creating that original plan. So a lot of times you simply restate that trust or make simple revisions to those documents.
Excellent. I want to thank you, Rick, for joining me today. But if anyone has any questions or would like to set up time to meet with me or Rick, feel free to contact our office or email me. We hope this webinar was helpful, and we just thank you so much for taking the time to be with us today.